The subject of trial by combat is one that has received a lot of attention as of late, whether that's in fantasy, such as in Game of Thrones, or whether it's in something like The Last Duel, the novel by Eric Yeager, which has recently been adapted into a movie by Ridley Scott. And you'll find a few videos here or there talking about the subject. However, the more I've looked into it, the more I've noticed that slight misconceptions keep getting thrown around about trial by combat. And I think that this is mostly due to the fact that when people talk about trial by combat, they neglect to talk about its place in a much larger, much more complex legal system of the various countries of the Middle Ages. So that's what I wanted to do today. Talk about trial by combat, but not just what it is, what its placement was in the overall legal system to maybe get a better understanding of why trial by combat was instituted. Now, a absolute 100% complete discussion of trial by combat for every single kingdom for the entirety of the Middle Ages would simply not fit into a YouTube video. So instead of doing an overall comprehensive view of multiple countries, instead what I'd like to do is take one example. I would like to talk about medieval England and specifically how England instituted trial by combat in the few years after William the Conqueror invaded England in 1066.
Side note really quick, I'm also going to be limiting this to a discussion of trial by combat in criminal cases, not civil cases. For those of you that don't know the difference, really quick, a civil case is a private dispute between two private parties. This would be something like a dispute over a contract or a dispute over a claim of land. Those cases, both in the Middle Ages and today, are different from criminal cases that involve crimes such as thievery, burglary, murder, things of that nature. Trial by combat was different between civil and criminal cases. I was originally going to put the distinctions between the two in this video, but I think that would just make the video entirely too long. Instead, I'm going to make a part 2. So this video, part 1, is going to discuss how and where trial by combat fit into the criminal legal system of England, which covers everything in the legal system leading up to the fight and what were the consequences of a fight's outcome. And then part 2 will discuss the procedures of the fight, including differences between criminal and civil, as well as differences between England and the rest of the continent. Without further ado, back to the video, except I'm going to provide a little bit of context of why we're only specifically looking at 1066.
We know that trial by combat existed long before 1066 England. However, pinpointing exactly what it looked like or how it was implemented is much harder prior to 1066. That's because 1066 in England is the first time that we actually get statutes and legislation laying out the process of how trial by combat is to be conducted. Everything before that, we only have stories, Norse sagas, and things from the Germanic people that tell us trial by combat existed. But we don't actually have laws, statutes, or legislation to tell us the exact details of how it was conducted. We of course have those stories and sagas, but it's much harder to take those and apply those in a broad sense to multiple people groups across multiple countries and definitively say that this is how all trial by combats went down. These stories could be the exception and not the rule. We simply can't know. But 1066 onward, we have it written in the law. This is how it's supposed to go. What is trial by combat? I know it might seem obvious, but we need to start here, because you would be surprised at how often people even get this one wrong. The other name for trial by combat is a judicial duel, and that is the touchstone of what a trial by combat actually is, a judicially sanctioned duel. The reason that I have to make this distinction is because many people will lump duels of honor, things like the duel between Alexander Hamilton and Aaron Burr, with trial by combat and conflate the two. These two things are not the same. Trial by combat is one of many options given to judges in the matter of sentencing. Pretty easy stuff. Most people don't get that one wrong. So let's start at the very beginning, how a criminal action gets brought to a judge in the first place. In 1066 England, the way that you brought criminal prosecution against another person was through the appeal system. Now, that word appeal might be tricky because this is a very different appeal than what we have in our modern day court system in the United States and in some other countries. Nowadays, an appeal typically means that the trial is already done and concluded and you are taking a matter of law to a higher court to review the lower court's decision to see whether or not the lower court got it right. The appeal that we're talking about here, though, is the trial level. It is one person bringing a criminal before a judge or before the court and saying, this person is a criminal and deserves to be punished. So the way that it works from the top down is that the king is in charge of all aspects of keeping peace in the realm. But of course he can't do it all himself. He's got to go fight wars in other countries. So he delegates it to judges. These judges ride around in circuits, visiting villages and towns, and asking the citizens if there's anybody in the village that needs to be prosecuted. Then comes the opportunity for people to step up and bring people before the judge. So Citizen A brings in a person that they've been keeping prisoner and says, "This person killed my father and he deserves to die."
Side note again, at first glance, this might sound like a civil case. You might be thinking, what the heck, you just said when a private citizen brings a private complaint against another party, that's a civil case. That is true. What the difference here is that the person bringing the suit before the judge is technically not suing the other person, they're acting as a witness. And also acting as a public prosecutor. They are essentially deciding who the state should prosecute. And they are not asking to be restored by the state or to receive any compensation, they are asking that the state punish the defendant. So a person brings a defendant before the judge, says they did a crime, and asks them to be punished. Okay, back to the vid.
Now, going from here, the judge has a number of options in how they could proceed. One of those options is trial by combat. Person A says, "Person B killed my father, and to prove it, I'll back it up with my life. Let me fight him to the death." So there's one option. The judge could sanction trial by combat, but another option is that the judge could make person B go through an ordeal. Ordeals were essentially these tasks that a person would have to go through in order to prove their sentence. Think Monty Python and the witch being weighed against a duck. That entire scene in Monty Python is actually a play on the ordeal of water, in which a person would be tied up, thrown into a lake, and if they sank, they were innocent. If they floated, then they were guilty. Other ordeals include things like the ordeal of hot iron, in which you would have to grab an iron that had just been raked in the coals, and then if your hand healed within 3 days, you were innocent. Now, the common thread between this and trial by combat is that it was essentially asking God to intercede on behalf of the accused, just in case the accusers got it wrong. The last and final option is that the judge could simply rule on the evidence that was presented to him. If the judge was convinced of a person's innocence or guilt, they didn't have to sanction trial by combat just because one person declared it.
A lot of side notes in this video, but I did not stress this enough while filming, and I have to stress this point because I cannot stress it enough. Trial by combat and ordeals were not the normal modes of deciding guilt or innocence. They were last resorts, and incredibly rare last resorts at that. A vast majority of the thousands of cases brought before the judges would have been very obvious from the get-go. So many people in the Middle Ages just got away with crime. In order to even be prosecuted, you pretty much had to be caught red-handed, meaning there would have been a lot of eyewitnesses. And in those cases, the judge would simply rule on the evidence. He probably wouldn't even allow trial by combat. But we'll cover more of that in a little bit.
Now, the biggest thing that always gets thrown out about trial by combat is someone will eventually say some version of this sentence. Trial by combat was so problematic because if you were strong, you could get away with any crime that you wanted. Not to downplay that concern, it was a concern, but it was a very minimal concern in light of other concerns, and it was also a very minimal concern in light of some of the benefits of trial by combat. First, let's address this point. Back in medieval England, there wasn't an organized police force or even town guard system for most villages, so the way that criminals were apprehended were simply by the citizens of each village. Villages, by and large, comprised of the same families who would know each other and recognize each other. So if a strange person is wandering about through your village, you as a villager are more likely than not to know that that's a shady character. And so the legal system that was instituted for apprehending suspicious suspects was something called hue and cry. If you caught a criminal in a criminal act, it was your responsibility to raise a cry throughout the town to get all of the townspeople together and go and apprehend the criminal. Kind of like how if you kill chickens in Skyrim, the entire town goes after you. If you're strong enough to beat the person that is accusing you in trial by combat, well, you're more likely than not strong enough to beat them outside of trial by combat before they apprehend you in the first place. So if you're the strongest fighter in the land, you probably don't even need to worry about engaging in trial by combat with someone else because you're probably not going to be caught in the first place.
And here I'm sort of talking about rogues or professional criminals. If you're a person of influence, that's a little bit different, but if you're a person of influence, number one, it's going to be a little bit harder to drag you before the court in the first place because of your influence. Or two, even if they manage to get past all of that, the evidence is probably going to be very stacked against you because, again, in order for you to be brought here in the first place, you kind of had to have been caught in the act, which means the judge is likely going to rule on the evidence and not let you go to trial by combat.
A much larger problem is that if you were an incredibly strong, incredibly skilled fighter, then you could falsely accuse someone and get away with it. The larger concern is not that people could get away with crimes, it's that they would be falsely accused of crimes.
And this is something that we see time and time again in the medieval legal system. They were obsessed with trying to counteract perjury or false claims brought before the court. And the system as a whole had a number of safeguards against perjury.
The result of a trial by combat, and actually the result of successfully going through an ordeal, was not that you got off scot-free, were declared innocent, and could just go about your business. No, the reward that you got for completing your trial by combat successfully is that you got to abjure the realm. You were banished. Essentially, trial by combat or ordeals were the judge saying, I don't know one way or another whether or not you were innocent or guilty, so just in case, we're going to appeal to God for a miracle. And even after that, the people were still not confident enough to say whether this person was guilty or innocent, and they said, we're still not sure whether you're guilty or innocent, so we're going to go ahead and banish you. We're not going to kill you, but we're going to banish you. Another procedural safeguard is that a judge could simply not sanction trial by combat. There's always the possibility that the judge just looks at the two of you and goes, nah, I've already made up my mind about the case, and here is exactly how I'm going to do the sentencing.
And again, this is one of the biggest differences between trial by combat historically and how it's portrayed in fantasy. In fantasy, it's almost portrayed as a right that if someone says, I declare by trial by combat, well, then they must have it. The reality is it was a tool in the judge's tool belt. The ultimate decider of whether or not a trial by combat occurred was a judge. And judges used it sparingly because they weren't stupid people. They knew that cases were better decided on the evidence. A trial by combat was a last resort.
And now we've already addressed how one of the biggest concerns was perjury or false accusations, but there were also procedural safeguards for that too. First, if person A brought a criminal accusation against person B, and the judge determined that person A was incorrect and person B was actually innocent, well then person A is going to get a pretty hefty fine from the court. Rule number 1 in the medieval courts of law in England is that the king always gets paid. He's got to raise money so he can be off in France fighting wars. So that's one safeguard against bringing false accusations. Another safeguard against bringing false accusations is trial by combat itself. Yes, trial by combat itself was meant to be a safeguard and an alternate to going through an ordeal. It was a way to keep the same concept of the ordeal, the appeal to God to intercede on behalf of the defendant for a miracle. It was a way to keep that concept and yet provide a procedural safeguard in the fact that the person bringing the accusation has to put their life on the line to defend their claim.
Now, this might be a counterintuitive thing at first because you might be thinking that a strong person would be really incentivized to commit perjury. After all, we just talked about how that was a major concern, about how we were concerned about really strong people falsely accusing others. The thing that we have to understand about this is that any sort of combat is a very unpredictable thing. Just because you are the stronger fighter does not necessarily mean that you are always going to win. One historical English swordsman even went so far as to say that when a person with skill fought a person without skill, more times than not, the person who wasn't trained actually won the fight. Or it resulted in both of their deaths because the untrained person was just so wild and unpredictable. Now, take that last part with a grain of salt. What this doesn't mean is that training wasn't of any benefit to you. What it does mean is that even if you were a trained or the strongest individual that you could possibly be, you still had to think twice about committing perjury because there was still always a chance you could lose your life. So the possibility of trial by combat was a safeguard even against strong fighters.
And as a last kind of humorous note, there were also ways that you could get out of trial by combat even if the other person declared it.
Slight slip of the tongue, meant to say if the judge declared it. These next ways are ways that you can get out of trial by combat even if the judge says, okay, we're going to have a trial by combat. So,
Trial by combat, although a Germanic tradition, was not a tradition of the Anglo-Saxon people, the people that made up a majority of 1066 England. William the Conqueror invaded with his Normans, but he, by and large, wanted to keep the Anglo-Saxon people happy. The way he did that is to, by and large, keep the exact same governing systems in place that were already there and just change some of the words to French. The way this fits into trial by combat is that there was actually an exception for Anglo-Saxon people. If a person brought you before the court and said, I declare trial by combat, you could say, no thanks, I'm Anglo-Saxon. I don't have to participate in trial by combat. Now, if you're a defendant in this case, that means that you probably have to go through an ordeal, or allow the judge to just rule on the evidence. But still, if someone else said, I declare trial by combat, you could say, no thanks, I'll take my chances with the hot iron. And in 1066 England, pretty much if you weren't Anglo-Saxon, you were a Norman. And funny enough, there were exceptions for Normans too. As a Norman, instead of submitting yourself to an ordeal, you could swear an oath in front of the judge and have the judge rule on your credibility in swearing that oath. So there are a lot of exceptions to trial by combat. It's not as simple as you see in the movies where someone says, I declare trial by combat, and everyone gasps, and by the law of the land now there must be a combat between these two people. And trial by combat is especially few and far between just 100 years later in 1166. In 1166 in England, we get something from Henry II called the Assize of Clarendon. What the Assize of Clarendon did for the system is establish the system for indictment. And this is the birth of the modern indictment by grand jury. Now, instead of one person bringing a criminal accusation against another, we have 12 people from the community all swearing an oath that this person is guilty. Well, that's great, but what does this have to do with trial by combat? Well, let's imagine this for a second. You're indicted by 12 different people. You're brought in, and you look at the judge and you say, I declare trial by combat. He's going to look at you and say, great, you're going to fight all 12? The system of indictment, by and large, destroys trial by combat, because you no longer have one person you can fight and ask God to intercede on your behalf for. Now, this doesn't mean that trial by combat goes away entirely. You can still bring an appeal even after the Assize of Clarendon was instituted, and you can still declare trial by combat if an appeal is brought against you.
But again, the credibility of being indicted by 12 different people made the system for indictment the preferred one over the appeal system. Appeals made up a very small fraction of cases, and appeals that ended in trial by combat even smaller. So now trial by combat is only in a fraction of cases.
Trial by combat was rare, and things like you see in The Last Duel even rarer. The Last Duel is actually a special case because in that time, in France, trial by combat was largely abolished. It was unheard of, which is why the details are so well documented. It was unheard of that a trial by combat would have been happening for something like that in that time. Medieval legal systems were more complex than they often get credit for. And when we look at trial by combat in the overall legal system, we can get a better understanding of what it was and why it was there. So thanks for watching. I hope you enjoyed. And if you have anything that you would like me to talk about, leave it in the comments below.